What's going on there, everyone? Jim Clark here. I'm an attorney, and I represent landlords and active real estate investors. We do the straight-up real estate closings, draft and negotiate lease agreements, contracts, and entity formations. All the things real estate attorneys typically do. But we also get involved in the more complex and messy stuff. The tenant evictions, complex real estate litigation, setup and compliant use of self-directed IRA structures, sophisticated asset protection planning, and partnership and joint venture arrangements and disputes. I've been in practice since 2002, and since that time I've seen thousands of deals, both in my own investing and for clients. As an attorney, I've worked with the best in the business, and I've gone toe-to-toe against the best. They say in real estate, you're learning something new every day, and that's true. But over the years, I've seen a lot, and I'm hoping that through these presentations, I can share some of these experience and what I know so I can help you become better at what you do. Before we get started, I just need to mention that the material provided in this presentation is informational only and not for the purpose of providing legal advice. You should contact your own attorney to obtain advice with respect to any particular issue or problem, and the use and viewing of this presentation or any of the links contained therein don't create an attorney-client relationship. The opinions expressed in this presentation are the opinions of my own and may not reflect the opinions of my firm or any individual attorney associated with us. Portions of this presentation may contain attorney advertising under the rules of some states, and prior results do not guarantee a similar outcome. And of course, if you need an attorney or think you might need an attorney, then by all means feel free to reach out to us. Our offices are in New York, and we're licensed to practice in New York, but we work with investors all over the U.S. And if we can help you, then if we can't help you, I should say, then we're happy to point you in the right direction. You can find us on the web at www.clarkslaws.com, or you can reach us using the contact information that you'll see throughout the presentation. Give us a call. I love this business. I love speaking with investors. I'm here in service to you guys, so by all means, hit me up. This presentation is free to you, but of course I encourage you to support it by subscribing and liking it so that we can keep doing what we do. So let's get to the matter at hand here. In the course of any month, I interact with many landlords and real estate investors through my presentations to local organizations, networking, as well as one-on-one conversations with landlords and investors. What I find is that the same questions often come up over and over again. So I thought it would be a good idea to start collecting the questions I get and then to record a short presentation focusing on the most popular questions so that the information could be of greater benefit to more people. If, as you're rolling along, you have any questions that you'd like to ask, please get them to me using the contact information below or through my website at www.clarkslaws.com, and then I'd be happy to consider it for a future Q&A presentation. I'm going to try to keep these presentations to no more than 15 minutes, but we'll see how that goes. Either way, I hope you find this information to be helpful. So now, with all that out of the way, and without further ado, I'll now run through our August 2018 Landlord and Real Estate Investor Q&A. First question. I have an IRA. This is from Justin. I have an IRA and I would like to start using the funds in my IRA account to invest in real estate. What do you think is the best way to go about doing this? I get this question all the time. With the market the way it's been, a lot of people are looking to get more control over their retirement accounts and the type of things that they're able to invest in, and they want to just invest in their own future and their own things that they got going on, and so they're looking for access to the IRA funds. If you get a self-directed IRA, if you have your IRA funds rolled over into a self-directed IRA, you can do it. The best way to do it, the way I most often recommend for investors, is to roll it over to a good self-directed IRA custodian, and we work with many. And after you do that, set up an IRA LLC. An IRA LLC enables you to be even more in control of your funds. When your funds are with a self-directed IRA custodian, anytime you want to do a transaction, you have to go through that custodian. The process can take time. There's a lot of forms, a lot of rules that the custodian has to follow, and that you have to follow as well, because these IRA rules have pretty drastic consequences. By putting it into a self-directed IRA, you have what's called checkbook authority, signature authority. The IRA funds are then in an account that you control, and then you, acting as the manager of the IRA LLC, can disperse those funds anytime you want. Of course, you're still subject to the prohibited transaction rules and other rules that are applicable to self-directed IRAs, but that's the way I usually recommend doing it. If you want to hear more, I'd be happy to talk to you more about that, but that's the broad overview. Next question. Stuart asks, I have a tenant in a commercial property of mine, and they're trying to pay me less than the full rent due because they're claiming that the condition of the property was bad when they first moved in and required them to spend a lot of money to bring it up to speed. The lease they signed stated that they were taking the property as is and they were fully aware of the condition. What should I do? Well, this comes up a lot. If you have a well-worded lease, and these types of disputes or issues are always going to be governed by the terms of the lease, first and foremost. If your lease was worded properly, and it's truly an as-is lease, then this is going to be a problem that legally is up to the tenant. Now, that being said, from a business perspective, you might want to make the tenant happy so that they stay there, they stay put, they pay rent. But from a pure legal perspective, you don't have to do anything. By virtue of the terms of the lease, as you stated, they were well aware of the condition of the property, they took it as is. These are all their problems. If they have financial difficulty, again, that's their problem. But as a practical matter, you might want to consider helping them out somewhat, although it should be on your terms. You shouldn't let the tenant say, I'm going to give you less than the full amount because of this condition. You should dictate the terms under which that happens, or tell them you got to pay the full rent and I'll help you with the condition of the property, something along those lines. Next question. This one's from Kenny. Do you have any investors that are in need of funds for their real estate deals? I have money to lend and I'd be willing to pay you a finder's fee if you link me up with an investor and we do a deal. Okay, this is a private lender looking to fund deals. Yes, I do have investors that are in need of funds. It always comes up, but I generally don't get involved, or as a rule, I don't get involved as a middleman collecting finder's fees for linking up investors, private lenders with my investor clients. In my book, that's a conflict of interest. I got a duty of loyalty to my clients, number one. That's the real estate investor. If I think you have money that could be of use to my client, and my client is looking for a private lender, of course I'd be happy to get you guys together, provided the client doesn't mind me disclosing their information. But I never expect any kind of finder's fee. Whatever I get has got to come from my provision of legal services to the client, period. But I appreciate the offer, and I would definitely be interested in if you have something that could be of use to one of my clients. Next question. This one's from Russell. I'm entering into a business with two other partners. We're financial consultants with established separate practices, and we would like to combine forces. What things do I need to be aware of in entering into a partnership agreement with them? Well, I guess this isn't directly related to landlords and real estate investors, although I see investors do partnership arrangements all the time. This particular question is from someone who is a real estate investor, but as their day job, they're a financial consultant. So what things we need to be aware of in entering into a partnership agreement? Well, there's a whole host of issues. A lot of it depends on the duration of your involvement with the other people. If you're going to be involved with them for just a short period of time, or if it's a deal-specific arrangement, then you might want to consider not doing a partnership agreement and doing something along the lines of a joint venture agreement. With that, you then have the ability to, if it's not working out, Once the joint venture agreement is up, you go your separate ways. With a partnership agreement, it's more like a longer term thing. It's like the difference between dating and marriage. With marriage, you're in it for the long haul, and to unwind it, you have to divorce the other person. Same thing with partnerships. I've got a list of issues, an outline that I usually provide to clients looking to do partnership agreements, and it basically lists all the different issues you got to be aware of. I usually give that to people that are looking to start a partnership, just to give, they're like discussion points. And what I find happens is a lot of times they'll go through this list of discussion points, and sometimes they won't even make it through the list, and they'll decide, yeah, this isn't for us because there are two different wavelengths when it comes to these issues. Better you find that out before you get involved with them and put money on the line than after. So if you're interested in doing a partnership, give me a call. I'll be happy to provide you with that list, that checklist, and from there you could see if it's something that might be useful, if the partnership even is going to work for you. Next question. I have a Section 8 tenant. She's been renting from me for 6 years. The apartment she lives in has failed its annual inspection, and I was told by the housing authority that I need to make repairs. She has become belligerent with me and will not let me in the unit to make the repairs. The housing authorities tried to intervene without success, but as a result, the housing authority is now withholding rent from me. Her lease is up next month. What should I do? Okay, well, I know it's disconcerting when the housing authority withholds rent, but while she's living there, you are entitled to the rent, and they do that often to incentivize the landlords to kind of rectify the situation. The housing authority can't evict your tenant, only you can as the owner of the property, and that's really what they're looking for you to do. Once that's done, they'll settle up with you as far as the rent goes. What to do about the tenant? With the lease being up in the next month, you're going to want to give them notice. Whatever notice is provided by the lease. If it's 30 days, give 30 days. If it just means not renewing, make sure you give that notice in accordance with the terms of the lease and the HAP contract, which is the housing authority agreement as well. Once you get rid of that tenant, then you'll be able to make your repairs, you'll get your rent, and everything will be back to normal. Next question. I'm trying to refinance, this one's from Jane, I'm trying to refinance a residential property that I own, but the bank will not entertain it. The title to the property is in the name of an LLC for estate planning purposes, and they're saying that they will not loan to me if title's in an LLC. What should I do? Well, this is a conundrum that's I see this very often when we do asset protection planning, because it's always a good idea not to hold property in your individual name. But when it comes to dealing with banks and refinancing and things like that, banks generally want to loan to individuals, especially on residential property. You're going to get your best rates if the bank is loaning to an individual. There are lenders out there that will loan to an LLC, but your rates are going to be higher. Your loan-to-value ratios are going to be lower. So there's really two things you can do. You can either stay in that LLC, get financing from a commercial lending source at the higher rate with the lower LTV, or you can do what's called stepping out of the LLC, in which you put the deed back in your individual name, do your financing with the bank, and get your cheap financing, and then take it from there. All right, so that's really all the time we have for questions this month. As we get closer to wrapping up here, I just want to reiterate that if you have any questions that you'd like to ask, please get them to me using the contact information below or through my website, and I'd be happy to consider it for a future presentation. If you have any feedback on how we can make this presentation better, feel free to use the comment section below or reach out to us. And if you like this presentation, then you can help keep it going by liking it to show your support, or subscribing so that you'll be notified when new content is posted, and so that we can keep doing what we do here and stand in service to you. So that's all the time we have for this time around. I'm Jim Clark. Thank you for tuning in, and we'll see you next time.